Hey, right, everyone, just bear with me whilst I do the usual. Uh, I've been having trouble on my second monitor recently, so I'm just going to try and do this tonight all in one screen. So I don't know if that's going to make it smoother or not smoother, but we'll see. Um, so yeah, it's just me and Karis tonight. So Will's doing an airport run, I think, and Shannon's off on a Holly Bob's for a week. So but I'm sure we'll be all right. There's three questions that have come in. Hey, right, Yaha. So yeah, there's three questions coming during the week, and then well, see what happens in the live stream. Basically, just let me pin that. So yeah, in terms of asking questions, I know people probably won't always hear what I'm saying here because they're going to come in later in the live stream. But basically, the rule is that don't ask questions about your own situation, or if you are asking questions about your own situation, put it in the third person, put it as a what if question because you'll get the same answer, but you don't have to share your personal data, and it also just changes the dynamic because ultimately we can't rescue anyone. We can't kind of come in and save the day or anything like that. We're just trying to help people understand the legal issues in their situation and try and kind of work out if they can find out what the answer is in that legal sense. I've had a few people recently kind of asking like two sides of A4 questions, and I don't even know what the question is by the time I read it all. So keeping it on point and keeping it kind of real short is actually a better way to understand it. You are Shadownet, nice to have you here, mate. And yeah, just to say as well, this ain't legal advice, so I'm not legally qualified at all, and Karis is, but ain't going to be giving legal advice here because it's just not possible. We're going to try our best to give useful answers, but that's about as good as we can do, really. So yeah, treat everything with a pinch of salt. Where we can, we'll try and refer to authoritative documents like the Code of Guidance or whatever. So yeah, that's the plan. So yeah, let's get to the slides, not the slides, the questions. Try and navigate my screen. So first question that's coming for the week is this one. Um, so yeah, so someone's currently living in interim accommodation pending a Section 202 review that they're and sorry and pending. So it's not pending anymore. The Section 202 has been not upheld, and now 21 days has passed, and they couldn't find legal aid for judicial review. The council have now terminated his interim accommodation. However, after receiving the review decision, he emailed their reviewing officer because he feels the officer overlooked medical documents that supported their case. The officer stated the medical evidence was over a year old and no longer relevant, and it will only reopen the review if more recent evidence is provided that contradicts what's stated in the review decision. So, first question with this, is it legal to dismiss evidence due to it being outdated? Secondly, can the person make a new homeless application since they're now threatened with homelessness? What are their options? And thirdly, can they still ask for a judicial review past the 21-day period due to not finding legal aid? So, good questions. I mean, I think the first thing I'd say about this is just because the council has upheld the not in priority need decision, that does not in any way suggest that you're not in priority need for this person. Councils just basically, it's the easiest way councils can wriggle out of their duties, other than kind of just barefaced gatekeeping, but by basically making perverse decisions where they're not properly considering the right evidence and so on, is their easiest way to avoid having a duty to house you. And so the first thing I say to this person is keep going and keep fighting it. But then these kind of questions come in of can they kind of continue fighting it even though the 21-day appeal, I assume this is the appeal stage has been missed. And the answer is if we start with or sub question two, yes, you can make a fresh homeless application. Um, and so let me kind of give you the basics before we tackle this, because the fact that the medical letter is like a year old, we'll come back to that bit. But this has always been a principle that you can make as many you can make as many applications to the same local authority as you want, provided there has been a change in relevant facts. And so by relevant, although it's not really kind of fleshed out particularly, in fact, I'll get the code of guidance up as well. We can have a look at the code of guidance to see where I'm getting this from. So uh, So it's 18.9, I think, or 18.7 or something. Let's try 18.7. No, that's the duty to refer. 18.9. Hold on. Let me actually share my screen. So yeah, so just for those who haven't been on the live stream before, this is the Homelessness Code of Guidance. Yes, it's called guidance. That doesn't, yeah, basically it's statutory guidance is telling councils how to interpret the law. So it is as good as legally binding, really, in my opinion. If they don't follow the guidance, then they're going to be potentially liable for compensation payouts for the LGO. So it's not 18.9. Which one is it? 18.11, sorry. So further applications. So chapter 18, by the way, is all about homeless applications. Brilliant chapter, best chapter in there. Why they put it at chapter 18 rather than chapter 2, I don't know. But basically says there's no period of disqualification if someone wants to make a fresh application. So someone who has gone through the process as this person has in the question, where they've basically asked for a review, it's come back, it's still not been overturned, it's still, they're still saying they're non-priority, then the person can trigger a fresh application. Um, Essentially, yeah, if I kind of go a little bit further, the housing authority will need to decide whether there are any new facts which render it different from the earlier application. If no new facts are revealed or any new facts are of a trivial nature, the housing authority would not be required to consider the new application and can instead rely on its previous decision. However, where the fresh application does reveal a change in relevant facts, the housing authority must treat the fresh application in the same way as it would any other application for accommodation. So any other homeless application, basically. So, and the kind of the idea here about relevant facts, and as I say, this isn't something I've seen specifically in case law, but I can't see it being anything else than this. You've got the five-part test within the homeless application process, plus you've got other issues like suitability. And let's say you have a situation where someone had been found to be intentionally homeless and the application kind of finishes, and then they became more vulnerable. So, they might have been vulnerable already. The council might have accepted they're in priority need already, but the issue is that they're intentionally homeless. If they then became more vulnerable, let's say they got another diagnosis or something of some kind of medical issue, that's not a change in relevant facts because the relevant factors is about intentionality. So what you need to do in that situation to make a fresh application would be to kind of obtain some kind of accommodation which might break that chain of causation, or some kind of new information. Now, I guess you could get medical information that comes up that might suggest you had fluctuating mental capacity that might have an impact on intentionality. So, but that's kind of what it's talking about. But I'm kind of doing this belt and braces. So in terms of the person that's asking the question, that's not a problem because in one sense the issue at hand is that the council says they're not in priority need, but there's this additional medical bit of evidence from a year ago. So in theory, this person can make a fresh application. There was a case earlier, right at the start of this year, called Ivory v. Welling Hatfield, and that just kind of emphasised just how easy it is to cross that threshold of there being kind of new information of some kind. In that case, basically, the case was rumbling along in court. I think it was in Court of Appeal. Meanwhile, there'd been this new psychiatrist report or new psychiatrist assessment done, which related to something which happened 8 years ago. So it was a new report, but it was about something that happened 8 years ago. And that was shown to be enough to basically start the process all over again and make a fresh application. So the issue in this case, so that I think that's so Karis, feel free to chip in. So I think that's kind of sub question two done. That we then come to this question of is it legal to dismiss evidence due to it being outdated? It depends what we mean by dismiss here, because the first thing to say is that if the review decision, the Section 202 review decision, doesn't mention this piece of evidence, doesn't even consider it, let alone dismiss it, then I would say it's not been dismissed at all. It's just not been considered yet. And so I would say you'll be able to trigger a fresh application with that information, provided it's kind of more than trivial. Obviously, we don't know what the contents of the assessment is. So that I would say that, yeah, I would say it's not, you can't just dismiss an old medical report just because it's old. It would just depend on the facts of the case. If the medical report was about the fact you had the flu a year ago, then yeah, it's probably not relevant at all now. But if it was actually that a year ago you got some kind of additional diagnosis, that's kind of some kind of long-standing condition, then obviously it could be relevant. It just depends on what the facts of the case are. Probably what I'd say though in this situation, what you'd probably be sensible doing is going to see your doctor again and just updating your doctor, telling your doctor how you're doing now that you're presumably homeless. That would probably have an impact on your health, and getting some kind of, it's just getting a fresh assessment. And if that fresh assessment throws up new information, it might be the doctor adjust your medication, it might be they up the dose or something, then that would be enough to trigger that fresh application. So obviously we don't know the details here, so we don't know if that's actually possible, but that would be the kind of default kind of go-to situation, what you do in this situation. Again, Karis, chip in with that, because I mean, I don't know of anything else here that would kind of be relevant, but it might be that from your point of view, there would be other stuff that would come in here.
I would just say, or they must consider all relevant evidence before making a decision. So if you've given it to them, they have to give it, even though they may say it's old, and that is quite a common thing. They'll say this is too old to be relevant now, or that's past, you're okay now. So that's quite common. But they have to give a reason, explain why it doesn't alter the decision, why it's not having an impact on the decision. Not that it's just to simply ignore it, but why it's not going to impact the decision that they've made.
Yeah,
That's something they've got to explain.
yeah. I think that's another kind of I mean, I would say it's generally, unless you're a solicitor, it's generally easy just to trigger a fresh application if you can with new information, because basically it just means you're dealing with lower thresholds and you've kind of got more opportunity. But to summarize kind of this kind of thing, I was looking at some case law on this today. The majority of council decisions on priority need, particularly from vulnerability, they fail because they don't correctly look at the actual relevant information. What the council need to look at closely is what someone's conditions are, what someone's diagnoses are, what their other social circumstances might be, but crucially, how they would be affected by being homeless. And certainly most case law that you see, councils, they don't actually seek information about that at all. They don't actually ask any doctors what's going to happen to this person if they become homeless. They might get a company called Now Medical or another kind of medical advisory service to kind of provide some information. But often all they'll do is they'll say what the person doesn't have. Like say, oh, they might have this condition, but they don't have that condition over there, so they can't be in priority needs. And it's been kind of, yes, it's not, yeah. I haven't seen a really good kind of council letter on this kind of thing, really, as in a council officer who actually understands what they need to be looking at. So they'll get like a patient summary or they might get a medical letter, but they still don't actually look at what's going to happen to those conditions if the person becomes homeless, and that's what you want to focus on. So it might be that your health hasn't changed for 10 years, but if you were able to get a letter from a doctor, which from your GP, which is another issue, which basically gave some kind of indication of what might happen to you if you were homeless, that would often be not only new information to trigger a fresh application, but also very strong very strong evidence, because to ignore it, the council officer would have to engage with that evidence and say why it is they think the GP's wrong. And because the Now Medical doctors don't meet the patient because they don't often see them full medical records, the Now Medical can't really come to the council's help legitimately. So that's kind of I think what kind of part of the answer here. Um, I think this third one. I don't think the fact. I mean, we talked about it recently. I think Will was lamenting this not too long ago, where judges don't seem to have a lot of kind of time, or some judges don't seem to have a lot of understanding for that. In fact, it's very difficult to get a solicitor involved a lot of the time. I think generally speaking, like out of time review or kind of Section 204 appeals would kind of be allowed where there are kind of like some, maybe that person's health is really bad, they're in hospital or something like that, and they just weren't able to kind of carry it at that time. Kara said I mean, obviously you've got more experience with that sort of thing. What other situations might someone be able to get an out of time appeal in?
And so it would be, you can ask for an extension of time if there's a good reason. For example, you were in hospital during that time, possibly that you couldn't get legal aid to it, but then they would say you could have, or you could have done it yourself. But there's also, you could not you could not secure the legal aid in time, you didn't know, so you can put it in because the Section 204 appeal is a county court. A judicial review is to a different court, it's a high court, so we would be going for a high court in this situation for a judicial review. But generally you need a barrister for that, so you could try a direct access barrister for that. And it does depend on the judge's discretion because to any court case that they accept, they could say, no, we're not accepting this CPR rule, this, that, and the other. They're not accepting it for this reason. and they could strike it out. So you apply to court and it goes to a judge first off to kind of, or to get allocated, to get reviewed, and you'll get directions of what you've got to do by a certain time frame. So you can still ask for a judicial review or a 204 appeal, even though the 21 days has passed, because you couldn't find legal aid. So you had to submit it yourself. So that's a good reason why it's late.
Yeah. I mean, as I say, as a non-lawyer, it's obviously a lot easier just to try and find something to trigger a fresh application. But if you can find a solicitor, then great. It's obviously not very easy these days, or probably for many days. I don't know how when it was ever easy to get a solicitor. But there's just an additional comment on the chat which I think ties into this question, so I'll stick it in there. No, not that one. Hold on. Let me actually copy and paste the right bit. But basically, is that going to copy now? Yeah, in reference to question one, review officer, the council sends a questionnaire to the GP with state and condition is still present. So yeah, so this is the issue is like this is where in one sense this is why it's not terribly difficult for a solicitor to tear apart a council priority need decision letter because they are they'll tell a ask a GP, is the condition still present, and the GP says yes. That is not the question at hand. The question at hand is what's going to happen to that condition if the person becomes homeless, if the patient becomes homeless. That's what matters, and that's what housing officers don't. I mean, the housing officers don't understand this. I don't think, judging by the way they write these template letters, like they probably don't understand it a lot of the time anyway. But that's just a questionnaire to a GP, unless it's focusing on what is likely to happen to this patient if this person was to become homeless, what's going to happen to their conditions, and let's face it, almost every health condition is going to get worse if you're homeless. Without that kind of level of detail, it's quite easy to attack council decisions and kind of get it overturned just because they haven't actually even asked the right question. They might kind of get that GP questionnaire which says yes, they've got this condition. They might have depression, and then they send that information to Now Medical, and Now Medical say, yeah, they're only on 100 milligrams of sertraline. It's not high dose. We don't think they're in priority need, which again is actually not legal because Now Medical shouldn't be giving an opinion about vulnerability anyway. That's another story. But then the council basically say, oh, Now Medical said it's not serious. That's it. But that hasn't even addressed the issue. It's not even asked the question, what happens to this person if they become homeless? Is there going to be a noticeable difference to this person if they became homeless when compared to the harm that a healthy and robust person would suffer? That's in effect the test. So it's kind of, it's really tied into that idea of what's going to happen to them if they're homeless. If I haven't said that enough times there, but yeah, that's yeah, so yeah, we've said all that, made it sound like it's easy. The reality is that it's not easy. Even yeah, you need with a new council. I mean, I'll kind of go into it a little bit, I guess. Here in Bedford, where I'm at and where I've done most of my casework, we have a very we've had a very high success rate with priority need arguments, but that is because we have kind of done it alongside complaining and raising things with politicians and all that sort of stuff, and Bedford's pretty good at it now. I mean, if you're not looking, they'll kind of do some stupid decisions, no doubt. But if you do then kind of lean into them and say, look, we think this decision's wrong, then the success rate is incredibly high. Like I can't think of one where it didn't come back positively. So, but that's first of all, that's not in London. London's a bit of a bit like the Wild West. And secondly, obviously, if you're actually homeless, you're not in a position to go and take on a council for 10 years. So yeah, I mean, any charity workers watching this is the biggest source of injustice within the homeless application process, and it's probably the area where you can have the greatest impact if you just apply yourself and get your head around this stuff and robustly challenge your local council, whether or not they fund you. Um, so yeah, are you right, Steve? So that's question. I think we've done question one there. Let's get on to question two. And this is a really quick one probably. So it's in relation to the video I did about complaints. Um, so and I'm not exactly sure what they're getting at here, but we're going to try and answer it anyway. So can you explain more about the time limit when it starts and what to do if a client has ongoing issues or you missed the deadline? So we're talking here about complaints and going to the local government and social care ombudsman, the LGSCO. They're kind of like the overseeing, not overseeing, but they're a bit like Ofsted, but for councils, I guess, and their job is to investigate individual complaints and see if the council followed the right process. And generally, I mean, this is a little bit woolly, but as far as I can tell, the LGSCO will investigate complaints which have gone through the council's complaints process within a year of the person finding out about the issue. And I think in most cases, it'll probably be assumed that the person should have known about the failure very early on, but it's not always the case. And obviously, if the council's own complaints process doesn't stick to its own timeline, then the LGSCO will extend their kind of, they'll accept later things. And also, there's been kind of decisions where someone was just literally rough sleeping for a year, and the LGO said, well, that person probably wasn't in a good place to be making complaints and pursuing it properly at that point. And so they are reasonable to an extent. But I'm not quite sure where it's written down any of that stuff. So as I say, it's a little bit woolly. That's just kind of what I've kind of gathered over the years of kind of seeing or reading LGO cases and kind of seeing what happens. So yeah, I've taken cases of the LGO where the LGSCO where the council's own delays both in providing the documents for the SAR for the subject access request and then actually dealing with the complaint itself just took more than a year. And the LGO were fine with it. They just basically say, yeah, that's fine. So yeah, because we did what we needed to do within the time limit. So yeah, and then thirdly, which is the last question. So if you haven't got, if you're watching the live stream, guys, now would be a good time to start asking questions. Otherwise, we're going to finish very early. So here is another question. So yeah, what if I'm currently in the process of making a formal complaint? Stated response received from the local authority and unsatisfactory. Subject access request also made and done as advised through official link, very delayed. Although, 3 months now. Request for all records from 2018 and specified housing and social care records, both adults and children's. Is there any way to speed this up? Also, how does one now escalate to the Housing Ombudsman? So first thing to say here is that although technically the Housing Ombudsman might be relevant, it's probably more likely to be relevant around local government social care ombudsman. Housing Ombudsman looks at social housing kind of failures like disrepair issues, stuff like that. And I think that's basically their remit. So obviously quite a big remit, but it's probably the local government social care ombudsman you want to be contacting if it's anything to do with the homeless application. Although confusingly, if the council put you into social housing as part of the temporary accommodation, for example, then it might actually the housing ombudsman might become relevant. I certainly worked on a case before where the LGO put the council put the family into temporary accommodation, which was run by a social housing provider, and there was like whatever, like lice, sort of just kind of some pests in there. And so it was actually the housing ombudsman that dealt with that aspect of the complaint. Anyway, from what is understood from previous lives, can only check. Trying to work out if I've misread that. Ombudsman can only challenge the process, not the decision itself. In this case, suitability based on medical grounds. Is it a waste of time going to the Ombudsman? Do you advise if legal aid solicitors don't have capacity to take on case? How can one get solicitors to take on a case? So a few questions in there. The first question is no, it's not a waste of time because there's actually the LGO when it comes to compensation payouts, often it's suitability issues, which are the biggest payments, so thousands of pounds potentially. Really easy where you're looking at things like disrepair. In fact, if you bear with me a sec, one of the so for those who are kind of like want to get into this in more detail, if you go to the LGO website, which I'll share in a minute, and you subscribe to the newsletter, you basically get like a weekly update of new cases. And I haven't read them today properly because they come through on a Thursday lunchtime, but I did see one today involving like damp and mold in temporary accommodation or something. Let me just have a little look. I'm sure it's in here somewhere. I may struggle to find it here. Yeah, here we are. So yeah, it was Newham. So let me just bring it up on the screen. And I've not read this yet, so I'm literally reading this for the first time. So yeah, this is what the decision looked like on the website. So it's lgo.org.uk. So summary of the complaint. Miss D says the council has failed to resolve disrepair issues at the current temporary accommodation. In addition, so that's kind of the overarching thing. The LGO explain what the laws are, they explain what the remit is, what actually happens, then that and do a little analysis of it somewhere usually. And in this case, can't be just 250 quid. That's nothing. Okay, so the council's already offered some compensation in this process. So here we go. So 3,000. So the council's probably, oh no, where is it? The correct figure was okay. So I don't know the detail, but that's the sort of money you're looking at. So it's for a 27-month period, so 2 years. That's you get 4 grand, so it's not a lot in the grand scheme of things. Plus they get another 250 quid. But if you read decisions like this, then you'll kind of get a feel of what the LGO can investigate. And actually, if I go to the decision database on Will's website, and if we just put in disrepair into the search as a keyword, you get all these cases pop up, and you can then kind of I'll show you how to use it. So in this one here, Rochdale involved a category 1 hazard. If we open it up, if we get the code from there, and then we go to the decision page on the LGO website, put that in there. We then get the full report. And again, it's same sort of thing. So this is an older one. This isn't from this week. But again, in this case, you're looking at 2 grand compensation, and it just explains how it all works. So yeah, I would suggest the kind of looking at that sort of stuff is not a bad way of doing it, to kind of get a feel of it. So yeah, Karis, you probably got some stuff to add to that, because it's very much up your alley in terms of stuff you do. So yeah.
I was just going to ask where this is the question where do I get advice if solicitors doesn't have capacity? How do you get solicitors to take on your case? So I'm at capacity now, so so is Will. So there's limited solicitors that do legal aid housing law now across the country. So I would just keep, but it changes quite quickly, so it could even change in the next day. So we prepare for worst case scenarios. So we'll prepare stuff to go to court if it needs to. But at any stage, the other side could turn around and say, no, okay, we'll readdress this and we'll retake a look. So then you aren't going to court, so you aren't spending the hours doing that preparation. So therefore capacity opens up. So it could change all the time. So I would just keep asking, phoning the solicitors or phoning around. That's how to get them to take on your case, I suppose, to get in the door.
So it might be worth us doing a video about this specifically, but and this might not be the same for you guys, but certainly for me. So I get people asking questions a lot, and I mentioned it already today. Like if there's a question which comes in and it's a page long, I'm not reading it. I don't have, it's not my job basically. I don't have time to do it. I've got other things going on and stuff. And so I'd say that it shouldn't, maybe it shouldn't be the way this is, but the reality is that when you're approaching people to try and find out answers to questions, the more homework you've done, the more reading you've done, the more you understand the issue, and the better you're able to concisely present your problem to a solicitor or to an advocate like me or something like that. You're probably going to find that you're probably more likely to get taken on, because ultimately, if you're at capacity and someone comes and says, you know what, I've got this situation, it's pretty open and shut. This is the issue. This is what he's doing. Then actually, it becomes much less kind of onerous to then take that case on. Whereas if you've got someone who tells you everything except the one thing you want to know, which does happen sometimes, it just makes it we're all human. It just makes it quite difficult to really kind of engage with it, because it just becomes this overwhelming thing. I mean, there's someone on the Facebook group at the moment, on the Homelessness Best Practice Facebook group, and they put pages of questions on there, and I'm like, I'm not reading this. I'm not even sure what the questions are anymore. I've answered the questions as best I could. So I think there is kind of something to say for that, in terms of just kind of reading up on what you can in a situation like this, getting the subject access request already, as quick as you can. Incidentally, on that issue, you can complain about it separately and take it to the ICO. It's not a quick process either, but it probably does some good to do that. But I think anything you can do to kind of be able to articulate your case as quickly as possible and as clearly as possible is not going to do you any harm. So yeah. Anything else on that one at all, Karis?
I would just say get your documents ready in date order.
Yeah.
So it sounds really bad. And your GP's information and medical information. What medical medication you're taking. I have a summary of that ready.
Yeah. Yeah, I mean, so again, if you're running a complaint yourself, so when I run a complaint, once I've got the subject access request documents, the first thing I do is kind of make a chronology. So literally bullet points of what happened when, what documents are relevant to it. You just find that it becomes much easier to then kind of manage. Yeah, just apologies, guys. My screen is like there's something wrong with my display drivers on my computer at the moment, so it's just weird what I can and can't see. Like icons don't come up, so I'm struggling to use the computer at the moment. But yeah, we've got this question's come up in the chat now, so we'll do that. No, hold on a sec. I can see if I'm going to get to it now. Yeah, like literally my let me see if I can just mess around with this for a second because my I can't actually see any of the chat at all now. I can see everything else but the chat. Here we go. So yeah, let me just get the question. Yeah, cool. Sorry about this, guys. Okay, let's try that again. So number 4, can the council find a homeless individual unreasonably homeless for a homeless individual not submitting a requested document yet? So this sounds like it might be one of two issues. It probably sounds more likely that the council is trying to say that the person is unreasonably refusing to cooperate with the personalised housing plan, as in they were told by the council to get some bank statements in the personalised housing plan, and this person hasn't done it yet. Now, there are some consequences potentially of not cooperating with a PHP, personalised housing plan, but the council first have to warn you. So if it's just a case of providing bank statements, then really, the council can't just kind of say it off the cuff, oh, you're not cooperating, that's the end of it. They'd have to write to you in advance and say, look, we're warning you, we don't think you're cooperating here. You need to do X and Y before X and A and B date or whatever. And and ultimately, bottom line is the quicker you provide supporting evidence, ID, bank statements, and so on, the higher the chances there of you getting social housing. That's just the way it works. I won't explain why, but it just is. So it's in your interest to provide those kind of those documents as soon as you possibly can. And if that means getting down to your bank or whatever, getting them to print it out, or just getting screenshots off your phone or whatever, then you just need to do it. I don't think. I mean, if the council's trying to say that you're unreasonably refusing to cooperate, I think you just need to cooperate now and it'll be fine. If a council then, I mean, intentionally homeless, no, don't think so. I mean, they could end the relief duty in theory, but then there was still a housing duty if you're in priority need, not intentionally homeless, and it's not, as I say, it's a different question from intentionality. So yeah, I think that's what the question. I think that's what the council's saying to this person. They're saying provide this ID or we'll end the relief duty. That's probably what they're trying to say. And if they're sort of doing that without following the right process, again, let's just go to the code of guidance because I'll show you where the process is laid out. Because it's a lot of council officers don't even bother trying it because it's such it's a lot of work to try and do it. Where is it? It's ending the circumstance in which both prevention and relief duty can end. So if I just put the word cooperate, unreasonably, let's put that word in there. We'll find it. So yeah, both prevention and relief duties can be brought to an end under Section 193B. Blah, blah, don't worry about that. If an applicant deliberately and unreasonably refuses to take any of the steps that they agreed to take, or the council or the housing authority set out for them to take where agreement cannot be reached in their personalised housing plan. But before bringing either duty to an end, the housing authority must first issue a warning letter. Issue a warning letting the applicant know that if they deliberately blah blah blah. So basically, there needs to be some kind of warning. It needs to be in writing. So really, if you're not complying with that request at the end of all that process, then yeah, they might end the relief duty. I mean, I don't see any. I'm sure there's going to be people out there who might be kind of like so disabled they can't leave the house and go to the bank. But in most cases, people can provide those documents. So I think just do it as quick as you can is the answer. Hopefully that was helpful. So yeah. Oh yeah,
Sorry.
sorry, Karis.
They would class as so they would sometimes they would say intentionally homeless. They could threaten with that, but it wouldn't meet the test because it's an administrative task rather than you're deliberately not doing something. But there's no reason for you not to supply your bank statements. So you're just delaying they could possibly be giving you the main housing duty, so you could be delaying that. And also if they're looking at accommodation for you, that's kind of their checklist they've got to adhere to. So acquire these documents from people. You get a list that you need to hand over. Something it's just cooperating with them and giving them everything they need. And it does include financial
Yeah.
assistance as well.
Yeah, I mean, I think if you have some particularly exceptional reason why you can't provide the statements, then tell them. But as I say, like just being busy or kind of yeah, obviously being homeless is incredibly stressful, and I'm not being homeless, so I'm not going to try and make it like sound like I know from experience, but ultimately you just have to do it. You just have to find the time. You just have to make it happen. Same with other ideas. Well, like as I say, like it's in your interest to. If you don't do it, nothing good will come of it, basically, even if it's just delaying it all. So yeah,
And you would be on record being accused of not refusing to cooperate and being difficult.
yeah, um, cool. So next question. Let's get this questions back up. Hold on a sec. My screen's come to life again. Um, right. So question 5. My friend is main duty accepted. That's good. She bids and she's always 50 to 100 on the queue number. What can she do to help her case? She wrote a template email to complain. She needs more advice on the best method. So really, unless the council have incorrectly banded you, as in giving you the wrong banding somehow, then there's nothing to complain about. Like if you're in certain boroughs in London, you might be main duty accepted 20 years ago and you're still waiting to get social housing. Um, so the only I think the only kind of way to sort of speed it up is to just to go look at the council's housing allocation scheme. If you search for the term housing allocation scheme on the website and the council's name, you'll find it, and that will basically explain how the bidding works. Now, generally speaking, if someone's been main duty accepted, there's only one band they'll get put in anyway, but there will sometimes be additional points or additional kind of banding you can get. Every council has got a different policy, so I can't tell you exactly exactly what it's going to say. But there are some councils that, for example, might give you additional points for having mobility issues. So obviously, it's possible to have be main duty accepted and not have mobility issues. But somebody who does might get additional kind of points or priority or whatever. I think that's the only thing that they can do really is just to basically look at the policy, check the banding is actually correct, and if it's not correct, then challenge it. But other than that, I'm afraid that's the game at the moment. It's, as I say, not unusual at all to be waiting a long time if you're particularly in London. Other areas in the country, it's very, very short or relatively short, so it's not all bad. But you've probably seen the headlines. I mean, there's some stats I did last year around kind of average waiting times, and there was another article which came out a few months afterwards, which was asking the question, how long would it take the council to clear its backlog of kind of people on the waiting list? And some of them were posting over 100 years. So yeah, unfortunately, there's not necessarily anything you can do to speed that up because there's 50 or 100 other people who are also main duty accepted who've been waiting longer than you have. So yeah, right. Cool. Just yeah. So there's some more stuff on the unreasonable. What's going on with my live stream here? I can't even see what's going on. Still, yeah, we're up to date. Yeah, cool. Yeah, so there's just more questions there about sort of the bank statement. Just provide it. Don't wait for them to send an angry letter. Just do it. Um, cool. Next question. I'm hoping you guys can see the screen because mine's not refreshing. I'm hoping you guys can see all this. Uh, so yeah, if you can't, let me know. So number 6, what advice if someone wants to get the remedy offer in a draft LGO decision increased? What if maladministration was found and led to worse health? So basically, there's I think we've talked about it before. If you Google the term LGO guidance on remedies, in fact, let's have a look at it now. In fact, we did it last week, I think. So I'm not going to do it again now. But basically, if you look at Google LGO guidance and remedies. You've got the different elements, and you basically work out, do you think the maths is correct? And there is like a section, I think, I can't remember if it's actual harm or it's called something like distress or harm or something like that. If you can show that it's led to worse health, not quite sure what level of evidence they'd need, but generally the LGO is pretty reasonable. Then it can increase your. I mean, there's the there's like a couple of weeks ago, I think it was Tower Hamlets. They basically had to pay 9 grand out to a family because there was damp and mold in the flat. The kid had asthma or something, and they could show that the damp and mold had led to this kid's asthma getting worse, and that was part of the reason why it was 9 grand, which is quite a high payment for kind of council, this sort of thing. So yeah, so I think the only way you can kind of challenge it is to um, have a look through the remedies document and see if there's anything they've missed. And also, my experience, when you're at that stage with the LGO, you can pick up the phone to the investigating officer and just have a sensible conversation with them and just see, what do they think? Because they might say, look, there is nothing else it could be. This is as much as we'd recommend. There's no point kind of fighting for more. But it's also, it's not rude to kind of try and ensure that you're getting the right amount. So it's not bad to kind of ask the question, but I think you just have to kind of listen to the response of the LGO officer just to kind of go with what they're saying. But yeah, by all means, raise a particular issue if there's something in the policy which you think has actually not been taken into account. So it's quite a good question here. I don't know the answer to it. You're right, Tiff. So let's put H there. Are councils and other organisations allowed to digitally exclude vulnerable tenants with disabilities? Surely everything can be done the old-fashioned way by pay forms. So I think yes. I mean, bear in mind, I've still got a Nokia phone. I've never had a smartphone, and I'm feeling the exclusion now because everything you need an app for it. But my understanding is yes, and I think actually, if you ask for it to be sent out to you in the post, then I think they have to send it out to you in the post. They certainly should allow, kind of make it available at the customer service centre. Karis, do you know more than I do about that one?
Yeah, so they're not allowed to exclude elderly people, so it'd be they have a duty under the Equality Act to make reasonable adjustments for people and to include people. But it is happening with a lot of people. BT even cut off landlines now, so elderly people don't have user access to their landlines now. So that's across the country. So there's no real way of requesting that back if they're going to cut it all off. So everything is going digital now, even car parking but councils do have an obligation to, if people request a paper form, send it out in a paper form. If it needs a large print, send it out in a large print. But yeah, it can be done.
Yeah.
But they will get, I suppose, difficult about it.
Yeah. Well,
Just have
I
to
mean,
request a number of times.
yeah. I mean, my experience of the kind of customer service staff who pick up the phone actually they're pretty helpful. So I think, yeah, if you ring the main office and say, look, I need X, Y, and Z form, can you send it out to me paper? I think they have to, for the reason Kara just said.
Yeah.
So, yeah, cool. Good. I mean, as I say, as Kara just said, I think it's something which is going to become more and more prevalent. But the Equality Act, I think, is still pretty clear about it. So, yeah. Let's get the next question. Oh gosh, press the wrong button. So, here we go. If someone is main duty accepted in Hackney, is there a chance to request moving to another part of the UK where you can get bid sooner? Not really, no. Once the main duty is accepted, you're kind of stuck with Hackney. Like legally, they can ask for a transfer to another council, but they ain't going to do that. They're just not. The other council won't. They just won't accept the referral. So, yeah, in that situation, I mean, I think we talked last week about the average waiting times. I mentioned it. I can't remember what it is for Hackney. I might be able to find it out whilst I'm talking. But it's not short. Um, I think the only thing you can do to speed things up, if you want to get sort of permanent accommodation, is going to go private rented. But that's obviously, I mean, I don't know. Depends how bad your temporary accommodation is, really. because I think generally, if it was me, I'd probably try and hold out for social housing. Because if you take private rented accommodation, you could be made homeless, in a year's time, and then you're back to square one. So yeah, it's a real difficult one. I'm just going to pull the stats up if I can find them. I keep forgetting where I've saved them. Saved them somewhere. It's called average waiting times. I don't have to search for it. I need to sort out my folders. Right. So okay, yeah, I've got it here. I'll just share the. So for those who kind of want to know the in-depth kind of figures, there's a video on the channel which I put up in January. It's called like average waiting times or something. If you go to that, I basically put the full details on the screen. But if we open this spreadsheet up now and go to Hackney, and there are a lot of caveats with this. So these are average waiting times for people owed the main duty, which this is what the person's asking about here. We don't know how many beds they're saying, but basically for average waiting times for a one bed in Hackney is 1,000 days, so that's like 3 years. For a two bed, it's 3,200 days, so that's like I guess like 8 or 9 years. But yeah, that's 4,000. That's like 12 years or something. So you can see in Hackney compared to somewhere like Alton, how much they differ around the country. Like Hartlepool, 84 days for a one bed. So unfortunately, this is not unusual in Hackney. So if we look at some other London councils, so Haringate's there. So again, you've got thousands and thousands of days to wait for certainly bigger properties. Greenwich is there. I mean, it's interesting how much it does vary around, even within London. Enfield's there. Yeah, so you kind of get an idea just how much it varies. But you got to treat these figures with a pinch of salt because first of all, it relies on the fact that when I asked for these figures from the council, they actually gave me correct figures, which is not always guaranteed. And it doesn't say anything about how long it might take to get private rented because the council can basically offer you private rented at any time once the main duty is accepted, and that could be the end of the duty anyway. So yeah, hopefully that's reasonably useful. Probably going to have to just call time on more questions from this point, guys. So if you've asked your question already, that's great. We'll answer it. But other question, you need to come back next week, basically. So that's the cut-off point. Let's try and find my place again. I've now lost it. Did that one. Yes, so I'm just making a point that some banks don't print bank statements, but it's a little so with banks and stuff, it's the same kind of thing as councils. Like they still need to make it available. It's still your data, so you can, if they're awkward about it, you can just do a subject access request and basically get everything sent to you. So, and obviously that's going to cost the bank more money, so they're better off just giving you the statement you actually need. I mean, again, not everyone's on online banking, but for those who are, it's dead easy to get the statement. So yeah. So sensible question, but I don't know the answer to it at all. So do you know a good place to get a dyslexia assessment in London by any chance? I do not, I'm afraid. Karis, to you. Let me just get those questions back up and running. There we go. Yeah, I don't know anybody of anywhere. I don't even know how you go about it. I assume you go through a GP, but I don't even know that much. Or if you go private, I guess. So yeah, no, I don't think we can help you there.
There's many private companies, but there is I think there's a national charity, Dyslexia UK. Well, I might be wrong. It's Age UK, isn't it? But it's something like that. And there's it's an assessment centre, so you got to apply, and you'll probably have a waiting list.
Yeah, I don't have any idea how much it might cost to go private. I assume it's hundreds.
I don't know.
Yeah.
It could vary.
Yeah. Okay. Next question. So what is the process of pursuing a data breach court case? What if council admitted to having a false record of someone being in prison, uncovered in a subject access request leading to multiple negative decisions? That sounds like that could be something which could result in compensation. I'd also be interested to know who that data was shared with, or who that misinformation was shared with. But to answer your question, there's a video I did a couple of months ago now because me and Will got a really good outcome with a data breach case earlier this year, and I was going to try and find the name of it. It was like literally like in June or something. And I think it was like how to obviously let me just search for data breach on the channel. If you go on the main channel, if you search for data breach, you'll find it. Yeah, so I did a video and it's July 13th of July it came out, how to claim compensation for data breaches. Have a look at that. Yeah, basically, it's as I say, it's something which it can be quite serious. I mean, one of the first complaints I dealt with like ages ago, like 10 years ago, was a guy who was mistakenly labelled to be a Schedule 1 offender, a sex offender, and he wasn't at all. No suspicion or anything. It was just like the admin work at the hostel was just rubbish. And if we'd known what we were doing back then, we'd have got him a massive amount of compensation. We only got him 2 grand in the end, but that's because we didn't know what we were doing, rather than the fact it wasn't worth a lot of money. So essentially, again, there's lots of kind of caveats with this, but where someone in effect accuses you of something which you can go to prison for, I think for over a year or something, or some kind of weird like thing like that, it's guaranteed to basically be libelous. I'm being very clumsy with how I say all that there, but that's kind of how it works. So it kind of depends on the ins and outs of it. But have a look at the video to that person, and feel free to ask us more questions, because I think data breach claims are a really good way to get councils to do a better job. So I think it's actually a very effective way of kind of pushing up standards. So yeah, I think I'm sharing my screen still. Yeah, cool. So how are we getting on? Done that one. So yeah, DSAR, so it's data subject access request. That so we generally it's called SAR, but that's what DSAR means. Cool. So another interesting question here. Do LGSO payouts affect universal credit thresholds? Not as far as I know. Not that I've ever got someone tens of thousands of pounds. But I don't know actually. So as I say, I've never got someone a payment. I think my biggest ever payment I got someone was like 4.5 grand or something. So um, yeah, I don't know what it'd be for. I mean, you're probably not going to get that much. Certainly with compensation I got I've supported people to get like outside of the LGSO process. It's kind of just kept away from benefits altogether. So it's kept like, people can keep it and still get universal credit. But I don't know how it would work if you got like 20 grand from the LGO, which happens incredibly rarely. So it's probably not going to happen. The highest I've ever seen was 27 grand for someone, but they were like a wheelchair user who got left homeless for like 2 years or something crazy. So it was like really stark. They're kind of like sleeping out sort of thing in a wheelchair. Um, so I don't know. I can maybe find out some more about this. Or if you ask that question next week when Shannon and Will are here, we might be able to. Yeah, I think Shannon kind of knows how the DWP works quite well, so she might have a better answer than I do for that. So yeah. Yeah. So next question here. Are applicants to councils outside London Greenbelt known belt going to be more likely to end up in council housing rather than private rented? Yes, absolutely. So if you don't care where you are and local connection doesn't apply to you in for whatever reason, it might be you're fleeing abuse, or it might be you've got multiple local connections or no local connection at all or whatever, then you're much better off approaching a council outside of London, because the waiting times are 5% of what they are in London. So if you can do that, again, you need to understand how local connection works, but it doesn't work the way councils say it works. So it's not unusual for people to be able to apply somewhere else for various reasons. So yeah. But the problem you got is the person who asked that previous question is that once the main duty's been accepted, you can't withdraw your application anymore, because if you basically leave that accommodation, the next council you approach will say you're intentionally homeless because you had in effect an offer of long-term accommodation. I know it's not come yet, it's only temporary still, but they would see it that way and they basically say you've left it without a good reason to. So yeah. So that's it. So we've now gone past the question. This is one real quick question there. So from memory, there are a couple of councils fairly close to London with very short waiting times. We talked about this last week in the live stream. We got the map up. But I think from memory, like Decorum and St Albans maybe or something like that, they were particularly good. I'll check the map now and just see what see if I can just show the map because as I say, not everyone can use this, but some people will be in a position to actually use this to choose which council they apply to. Which, yeah, for example, survivors of domestic abuse, you can kind of go where you want to. There are a couple of caveats with that as always, but so if we zoom in to so Decorum, East Hertfordshire, Wokingham, all pretty good. South Oxfordshire, not terribly, not a long way from London. Epping Forest, even not bad. I spoke to someone last week actually who waited 18 months to get into somewhere in Epping Forest. So yeah, but you just see how much it varies. Even within London, it varies quite a lot. So this is Hillingdon over here, which a yellow is between 100 and 200 days. But as I say, there are caveats with that, as I've said. So don't use this data without watching that video about it because it explains how to understand this data. Because this has absolutely nothing to do with I'm not even sharing the thing yet. Hold on a sec. Sorry, I'm not sharing the screen, am I? Yeah, sorry. So I was just saying there, guys. So yeah, these are the kind of green areas are like less than 100 days basically. So light green is or bright green is 50, and then light green is like under 100. Um, but yeah, as I say, you need to watch the video to see the caveats. The Hillingdon's numbers might be as low as they are because they literally don't house people in social housing. They just house people in private rented who are on the maid duty. So it's not an exact science. It's just a good indicator. Certainly the figures around Bedford. So I'm in Bedford. Central Beds is a neighbouring one. Central Beds is genuinely a better council to approach than Bedford, as one example of many. So yeah, cool. They're less. So I just trying to follow this. So less likely to end up in council housing applying councils outside the green belt compared to London. No, so it's not they're less likely. That's not quite what I said. It does depend, but just remember that those average waiting times, they are taking into account that you have the option, or councils have the option of discharging into the private duty into the private sector. So yeah, um, yeah, watch the video basically. I think I'll find the name of the video if you want to find out more about it. So because it's about 20 minutes long, but it's got all the figures in it, and it just kind of explains how to interpret them. How long? Yeah, so the video is called "How long does it take to get housed?" And then the thumbnail says average waiting times. It's from the 2nd of January this year. So yeah, yeah, it's a video I put like probably a month's worth of work in to get all that data from different councils. So, but I think it's worth it because it can genuinely change someone's prospects. Just to give you an understanding how it worked in some of my casework recently. Survivor of domestic abuse approached Bedford. They had no reason to be in Bedford, particularly. They didn't know anyone here. And so when I spoke to them, I said, Bedford's got a duty to house you, but would you not rather go to Central Beds? Because the waiting time's half of what it is in Bedford, and Central Beds is a nicer place. And they said, yeah. And so we withdrew the application from Bedford, went to Central Beds, and main duty was accepted about 2 months later. So that's kind of how it can work. But obviously, it's not always that simple. So, yeah, that's it, guys. Bang on 8:30. We'll be back. Karis, you around next week? I'm around next week. I don't know if Will and Shannon are, but I think Will is. But we'll find out. But yeah, hopefully that's been useful, guys. As I say, hopefully there's something useful within all this stuff. And we'll see you next week. Just kind of keep going. I think kind of the answer to a lot of these questions is just kind of be really methodical about it when you're making complaints, when you're kind of crunching through this process as much as you can. Just kind of break it down into steps and just do the steps. And just keep track of everything. When you make a complaint, just assume that they're not going to respond within the waiting, the average time. So when I make a complaint, I'll put a note in my calendar saying Bedford Borough Council should have responded by this date, and if they haven't, I'll then just kind of chase it or take it to stage 2 or something. So that's kind of it.